Judicial activism, origin and meaning. The concept of judicial activism originated and developed in the United States. The term was coined in 1947 by Arthur Schlesinger in his article, The Supreme Court, which appeared in the Fortune magazine in 1947. In India, the doctrine of judicial activism was introduced in mid-1970s. Justice R.N. Bhagwati, Justice D.A. Desai, Justice V.R. Krishna Iyer, Justice O. Chinnappa Reddy laid the foundations of judicial activism in our country. Judicial activism denotes the active role played by the judiciary in protecting the rights of the citizens, in the promotion of social justice, and examining legislative and executive government's decisions. Judicial activism implies the role played by the judiciary in nudging the other two organs of the government to discharge their constitutional duties and rectifying errors made by them to ensure efficient and timely justice and relief. Judicial activism motivates judges to go beyond statutory precedents and adopt a progressive method in settling cases. Judicial review, public interest litigation, supervisory power of the high courts, over lower courts, and constitutional interpretation are the methods through which judicial activism is carried out. Thus, the judiciary renders justice in keeping with the times by going beyond its traditional scope. Evolution of judicial activism. The evolution of judicial activism is divided into three stages. First, 1950 to 1970. During this period, judiciary stuck to procedures embodied in the Constitution. Second, 1970 to 2000. During this period, judicial activism was established by some judges who went out of their way to deliver judgments which touched various aspects and brought relief and justice. Third, 2000 onwards, during this period, judiciary moved to areas beyond its jurisdiction like women empowerment and environmental protection, preservation and sustainability. Significance of judicial activism. The reasons for judicial activism are as follows. First, protector. The citizens look up to the judiciary for the protection of their rights. Thus, judicial activism upholds citizens' faith in the constitutional and judicial organs. Second, guardian. The legislature and the executive may fail to discharge their functions. For example, in case of a hung legislature, the government is unable to take any decision which displeases any caste, group or class because of fear of losing power. In such situations, the judiciary is an effective tool for implementing constitutional principles. Therefore, the judiciary is regarded as the guardian of the Indian Constitution. Third, social reforms. Society is not static, it is dynamic. The judiciary's involvement in social reforms is visible due to the shift from the principle of locus standi to PIL. Fourth, vacuum filling. The inaction of the legislature and executive creates vacuum or gaps in certain areas of legislations. During court hearings, the vacuum is filled by the judiciary. Thus, the judiciary is not a mere spectator. Judicial activism gives judges the power to make decisions that support innovative and progressive social policies. As a result, it builds faith in the minds of the people that justice will be delivered without fear or favor. Judicial activism in India. The beginning of judicial activism can be traced back to 1893 when Justice Mehmood of the Allahabad High Court issued a dissenting opinion that sowed the seeds of activism in India. He criticized the rule that appeals should be dismissed on the grounds that the petitioner was unable to pay for the translation and printing of the record in English. After independence, the courts were technocratic in nature, held judicial and structural view of the constitution, and followed the procedures that they were expected to do. But some judges went out of their way to deliver judgments that today are considered as foundations of judicial activism. The nationalization of 14 major banks in 1969 and abolishing the privy purse of the Indian princely states in 1971 were the steps taken by the then Prime Minister Mrs. Indira Gandhi to fulfill her election promises and to serve the interest of the poorer sections of the society. The judiciary was still traditional in its outlook, and therefore they declared the law passed by Parliament and signed by the President of India as null, thus overturning her attempts to serve the people of the country. Prime Minister Indira Gandhi regarded this decision as judicial overreach. So while appointing the Chief Justice of India, she set aside the three senior-most judges who had overturned her attempts and appointed Mr. A.N. Ray, the dissenting judge who was fourth in line. This led to the resignation of the three senior-most judges. Thus, the conflict between the executive and the judiciary laid the foundation of judicial activism. The Supreme Court ruling provides an understanding of the developments of judicial activism. The cases are as follows. In 1975, Justice Jagmohan Lal Sinha from the Allahabad High Court found Mrs. Gandhi guilty of electoral malpractices and declared her election from Rai Bareli null and barred her from holding elected post for the next 6 years. This shows activism on the part of judiciary to dispense justice fairly. Second, in Hussain Nara Khatun versus State of Bihar in 1979, the Supreme Court directed release of under trials on personal bonds. The court pointed out that speedy trial was a fundamental right and cannot be restricted due to money or lack of legal representation. This decision was taken because the under trials had already served time for more period than they would have had they have been convicted. Third, In Olga Teles versus Bombay Municipal Corporation in 1985, the Supreme Court observed that sidewalks or any other places reserved for public purposes cannot be encroached, but directed the BMC not to evict the slum dwellers until the end of that particular year's monsoon season, and sought resettlement based on certain criteria. Fourth, Bandhu Mukti Morcha versus Union of India in 1997 case, the Supreme Court ordered the Haryana government to constitute a vigilance committee within 6 weeks in each division of district to ensure compliance of the guidelines laid by the Supreme Court and appoint a district magistrate to identify the bonded labor practiced in the country. The Supreme Court directed the government to rehabilitate the bonded laborers within 3 months and to ensure that minimum wages are paid to the laborers, to ensure sanitation and medical facilities and unpolluted environment during working hours, and to conduct awareness drives to impart knowledge to the laborers about their rights, to ensure that no one is treated in an incorrect and inhumane manner. Fifth, Indira Sahani versus Union of India 1993 case, the Supreme Court laid down that reservation cannot exceed 50%. Reservation in promotions cannot be allowed. Classification of backward classes into backward and more backward cannot be allowed, and the concept of a creamy layer was laid down, and this layer was to be excluded from reservation. Sixth, in Justice K.S. Puttaswamy retired versus Union of India 2018, the court recognized the right to privacy as a component of the right to life and personal liberty. Seventh, in the case of Navtej Singh Johar versus Union of India 2018, the Supreme Court declared a portion of Section 377 of the Indian Penal Code to be unconstitutional and stated that it violates the right to life and liberty guaranteed under Article 21 of the Constitution. Eighth, in the case of Shakti Vahini versus Union of India 2018, the Supreme Court ruled that the right to choose one's life partner is a fundamental right protected under Article 21 and ordered the government to take all reasonable preventive steps to prevent honor killings and related crimes. The Indian judiciary took an active role in protecting the environment for the benefit of the population. Beginning with the rural litigation Kendra case versus State of UP, which was concerned with limestone quarrying in the Mussoorie Hill Range in the Himalayas. In this case, the court introduced concepts like sustainable development and polluter pay. The court also adopted concepts from international treaties like Stockholm Declaration, Rio Declaration, Biodiversity Convention, and Kyoto Protocol. The Supreme Court elevated the right to clean and healthy environment to the status of a fundamental human right under Article 21. Second, in the MC Mehta versus Union of India in 1986, known as Taj Mahal case, the Supreme Court observed that not only chemicals but also socio-economic factors led to degradation of Taj. The court also observed that people's life was at risk due to air pollution. To prevent Taj Mahal's white marble turning yellow and to improve people's life, the court ordered the industries to use safe fuels or to relocate. The court ensured that workers received wages during the time taken for relocation. Third, in the MC Mehta versus Union of India in 1988, known as Ganga pollution case, the Supreme Court directed the industries to ensure that their waste was properly processed and released, license to be granted if company can demonstrate an appropriate method of waste treatment, municipality must take proper action and provide adequate drainage and sewage system, ordered the federal government to provide free publications to the public in order to improve public awareness of environmental issues. Fourth, in the Milkman Colony Vikas Samiti versus State of Rajasthan 2007, the Supreme Court ruled that the right to life includes the right to clean environment which contributes to a healthy body and mind. Fifth, in Arjun Gopal versus Union of India 2018, the Supreme Court stated that no one may be permitted to infringe on the right to health of others granted under Article 21 under the guise of celebration. The Indian judiciary has taken steps to prevent exploitation of women and to improve their conditions at workplace. This has been observed through many decisions of the court. For example, first, in the case of Air India versus Nargesh Mirs, 1981, the Supreme Court ruled that the rule requiring an air hostess to leave her job on her first pregnancy was invalid because it violated Article 14 of the Constitution. Second, in the case of Ahmed Khan versus Shah Bano Begum, 1985, the Supreme Court overruled the Muslim law and extended the iddat period to provide justice to Shah Banu. Third, in the case of Vishaka versus State of Rajasthan, 1997, the Supreme Court put forward various important guidelines for the employers to follow and to avoid sexual harassment of women at workplace. The objective of the court was to ensure gender equality so that there is no discrimination towards women at these workplaces. Fourth, in the case of Lakshmi versus Union of India 2015, the Supreme Court put restrictions on the sale of acid. The court also emphasized that dealers have to sell acid to customers who have valid identification and can justify the reasons for the purchase. And the dealer has to notify the police within 3 days of the sale of acid, and that it cannot be sold to anyone under the age of 18. Fifth, in the case of Railway Board versus Chandrima Das 2000. Employees of the Indian Railways gang raped a Bangladeshi national in a room at Howrah's Yatri Niwas station. The court held the Union of Indian Employees who were managing the establishment, including Yatri Niwas and the railway station, were held liable for compensating the victim. Sixth, in the case of Defense Secretary versus Babita Punia 2020, the Supreme Court ruled that excluding women from command positions is unreasonable and unlawful because it violated Article 14 of the Constitution. Merits of judicial activism. The merits are as follows. First, prevents misuse of power. Judicial activism helps the judiciary to keep a check on the misuse of power by the legislature or the executive. Second, protects fundamental rights. Judiciary upholds citizens' rights by implementing constitutional principles. Third, faith in judiciary. Though it is not an elected body, the apex court is known for upholding the rule of law. Fourth, speedy justice. The legislature takes time for framing laws because the laws require majority for approval. It is in such situations the judiciary frames laws and resolves issues. Demerits of judicial activism. The demerits are as follows. First, sets a standard. The decisions taken by the judiciary becomes the standard for ruling in other cases. For example, Maneka Gandhi versus Union of India. Second, repeated intervention. People lose faith in the efficiency and integrity of the government because of repeated court intervention. Third, selfish motives. Judgments may be influenced by personal or selfish motives which harms the public at large. Fourth, limits legislature and executive powers. The legislative powers and the executive mandate is curtailed by repeated judicial decisions. Fifth, lack of expertise. Judiciary lacks time and resources to enact legislation. Sometimes practical differences of such enactments are not known to the courts. For example, ban on BS4 vehicles from 2020, which has been extended many times. Sixth, judicial adventurism. The organs of government must function in its own sphere. Otherwise, it may lead to judicial adventurism. For example, Subhash Kashinath Mahajan versus State of Maharashtra 2018. Hence, legislation enacted by judiciary must be only in rare cases. Judicial activism that goes beyond all justifiable limits is referred to as judicial overreach. Parliament has charged the judiciary of judicial overreach. Judicial overreach means that the courts arbitrarily and repeatedly interfere into the domain of the legislature and the executive. Judicial overreach comes in the way of functioning of healthy democratic institutions. The fundamental constitutional principles are violated. The principle of separation of powers are violated. It goes against the law's supremacy, which is guaranteed by the rule of law. In a democracy, the legislature and the executive are held accountable for their actions, while the judiciary is in no way accountable even if it intervenes because the courts operate independently. To maintain the balance of power among the branches of government, the Supreme Court has emphasized the importance of judicial restraint. For example, in the case of S.R. Bomaya versus Union of India 1994, the court stated that there will be no judicial review when there is political interest involved. Second, in the case of Almitra H. Patel versus Union of India 2000, the Supreme Court rejected giving the Delhi Municipal Corporation instructions on how to clean Delhi, claiming that the matter was outside of its purview. Third, in the divisional manager Aravali Golf Course versus Chandarhas 2007, the Supreme Court stated that judges must know their limits and are not to run the government. Each branch of government is obligated to respect the others and refrain from encroaching on their domain. Fourth, in the government of Andhra Pradesh versus P. Lakshmi Devi 2008, the Supreme Court stated that invalidating a legislative act is a grave step that should never be taken lightly. Fifth, in Minor Priyadarshini versus the Director of Elementary 2016, Justice Markand Kaju stated, under the Constitution, the legislature, the executive, and the judiciary each have their own broad sphere of operation. If any of these three state bodies venture outside of their respective jurisdictions, the Constitution's delicate balance will be upset. The role of judiciary has been under attack because the legislature and the executive feel that the courts are crossing their power. But the judiciary has argued that due to legislative and executive inaction, the judiciary had to step in and pass the directions. Let us see examples of judicial overreach. First, in the case of Shyam Narayan Choksi versus Union of India 2016, the Supreme Court made it mandatory. First point, all the cinema halls in India should play the national anthem before the feature film starts. Second, the national flag should be displayed on the screen. Third, all present in the hall are to stand up to show respect to the national anthem. Fourth, the entry and exit doors will remain closed while the national anthem is being played or sung in the cinema hall. Judicial overreach. First point, the court did not refer to the Bijoy Amule case. In this case, 3 children were expelled from the school in Kerala for not singing the national anthem because their religion did not permit them to do so. The court ruled that there is no legal provision that obliges anyone to sing the anthem and ordered the school to take back the children. Second, the court had ignored situations where people may not be able to stand up for physical or religious reasons. Third, the court ignored its earlier ruling in the Upahar tragedy, where it held that under no circumstance should the doors in the cinema be shut from the outside. Fourth, this order will face implementation issues. Fifth, the order goes beyond the prevention of insults to national Honor Act 1971. Second, the Lodha Committee was established due to the report submitted by Justice Mukul Mugdal Committee after an investigation into the 2013 IPL betting scandal. The recommendation of the committee are as follows. First one, BCCI should come under RTI. Second, more than 2 consecutive terms of holding office is not allowed. Third, there will be only one post per person. Fourth, ministers or government servants cannot hold positions in BCCI. Fifth, cricket bodies that represent states will have full membership and voting rights in BCCI. Judicial overreach. First point, it is not for the court to run a sports body or to prescribe how it should be run. External interference hampers the development in these areas. If they have violated the rules or their position, they must be ordered to follow the prescribed procedure. Second, the BCCI is registered and governed by the Tamil Nadu Societies Act. The BCCI is an independent body with its president, secretary and office bearers who are elected on the basis of bylaws. The BCCI is not aided by the government. As a result, the court could have instructed the BCCI to follow the provisions of the Act instead of making recommendations. The other examples are: third, censorship of Jolly LLB 2. Fourth, liquor ban. Fifth, 2G spectrum case. Sixth, ban on firecrackers. Seventh, National Judicial Appointment Commission. Eighth, children of public functionaries, bureaucrats in UP should be enrolled only in government schools.